Down in the city, where the shadows grow so tall, there's a woman named Karen, caught up in it all. They say she did wrong, but the truth's hard to find, 'cause the law's got dirty fingers and justice is blind. Whoa, justice blues in the pale moonlight, when the one sworn to serve you don't do what's right. Whoa, justice blues, it's a cold hard fight in the dark of the night, where corruption takes flight. They twisted her story, turned the facts all around, made her out to be guilty on shaky ground. Evidence vanished and the lies start to flow, but the deeper you dig, the darker it grows. Oh, justice blues in the pale moonlight, when the one sworn to serve you don't do what's right. Oh, justice blues, it's a cold hard fight in the dark of the night, where corruption takes flight. She cries out for fairness, for a glimpse of the truth, but the powers that be, they ain't got no proof. The badges and the ties, all woven with deceit, in this twisted tale, it's the innocent they cheat. Oh, the courtroom whispers and the gavel strikes down, but the air's filled with tension neath that judge's frown. Karen stands there strong with fire in her eyes, for she knows deep inside the real crime's in disguise. Whoa, justice blues in the pale moonlight, when the one sworn to serve you don't do what's right. Whoa, justice blues, it's a cold hard fight in the dark of the night, where corruption takes flight. One day the truth will rise like the sun in the sky, and the lies will crumble, no more alibis. But until that day comes, she sings a mournful tune of the justice blues neath the pale haunted moon. Out for fairness, for a glimpse of the truth, but the powers that be, they ain't got no proof. The badges and the ties, all woven with deceit, in this twisted tale, it's the innocent they cheat. In this twisted tale, it's the innocent they cheat. In this twisted tale, it's the innocent they cheat.
Hey, good morning, good afternoon, good evening, good night, whoever you are, wherever you are, whatever you're doing, whoever you're doing it with, however good it feels, however many times you're going to do it, and why you're even doing it in the first place. I don't care. I'm just glad you're doing it here with me, Legal Vices, on this little old channel we like to call Legal Vices, because I'm clever and creative that way. Today we are looking at some big developments in the Karen Read trial. We've been backed up on a lot of things because of the Karen Read trial, and then subsequently the relatively short Alec Baldwin trial, the much shorter than expected Alec Baldwin trial, and the aftermath that we've been dealing with for a few days, the dismissal of those charges with prejudice. Let me turn off the oldie phone. All right, there, we're now muted. Sorry about that. All right, so that's what we're going to be doing today. We're going to be looking at some of the new developments. You may know all of them. You may have heard some of them. You may not even know about any of them. So that's what we're here today to do, is to discuss these changes and get you right up to date with the most recent developments in the Karen Read trial, and we'll continue to follow them as the case progresses and as the as the Commonwealth decides whether or not they're actually going to retry her on the charges, and if so, what charges, or is the judge going to throw the whole thing out? That's sort of where we are now. And apologies already. The dogs are already snoring here at my feet. We had a rough and tumble evening, so we played a lot. They're just plumb tuckered out. Right. Jeff stole the hat from MG Law. Oh no, this is an oldie but a goodie. It's just the Alec Baldwin trial's over, so I don't have to wear the cowboy hats anymore. All right, starting us out, we got Matilda with the €2 super chat to kick us off with the super chats. Good afternoon from the Netherlands. Well, good night from Korea. You'll be here in no time at all. Thank you so much, Matilda, for kicking us off. And this is a good time to remind you that the super chat option is there. We don't grift for it. We usually don't raise it more than we absolutely have to, but as long as we're talking about it, not required, not requested, but always graciously and gratefully accepted. Anytime you guys part with your hard-earned money to support me, I do not take that for granted ever, and I graciously accept it. Really, what it does is guarantee, not only does it support the channel, of course, but it guarantees you get your comment read and responded to. I try to pay attention to chat as much as I possibly can while doing the show. When we're watching videos and stuff like that, it's a little easier to pay more attention to the chat. But on days like today, where it's very, very reading heavy, it's hard to pay a lot of attention to chat. So if you really want to get my attention, if you really want to say something, that's unfortunately the best way to do it, because it comes up in all these bright, pretty colors, and we can make a whole rainbow if you want. We have a plethora of colors. So super chat if you want, not required, but it does, as Matilda knows, guarantee that you get your super chats read. And sometimes, if I'm not paying attention, you get it read twice, or on F at Fridays, sometimes several times. Speaking of which, what's coming up real quick this week, the weekend preview. Tomorrow, I haven't decided yet. We're either going to be doing Laura Owens, or we're going to be doing What the Hales, catch up on one of those two cases. Thursday, we're going to be doing our retro trial, Florida v. Donald Hartung. Hartung was the man who was accused of murdering his two half-brothers and his mother in a witchcraft and or ritualistic manner. We're going through his trial. You don't need to have followed anything. It's a very easy trial to follow. So Thursday for that, and then Friday will be F at Friday. We're going to do an F at Friday this Friday. So bring your coins, toss a coin to your law racks, and it'll be the usual shots for money. We'll throw together a good panel of people as always. I haven't decided if it's going to be Friday morning U.S. time or Friday night U.S. time. I'm waiting on one text message that tells me if I'm doing something on Saturday or not, and then I'll let you know. Unhung Hero with the second super chat of the night with the $5. How long will it take for Aunt Bev to respond to this? Ooh, good question. But first, we have to get to what she needs to respond to. And right now, we got 369 people. We have 369 people here and 179 likes. So basically, 190 of you haven't done your job. Get down there and hit that like button. I saw some banter in chat at the beginning. You shouldn't be allowed to like something. It hasn't started yet. Says CRC Duster. 365 dislikes. I wish, but no, unfortunately, even I don't know how many dislikes I get. But we people saying, I shouldn't be allowed to like before it starts. Well, clearly, if I'm in charge here, clearly, if I'm doing a show, you're obviously going to like what you see. So that's not even a question. If it's my stream, you're going to like it long before it starts. So just get it out of the way and hit that like. And if you haven't subscribed, please do me the favor. And if you have, just double check to make sure you still are. We're pushing our way towards 77,600. I don't even know where we are. We're at 77,581. So we're 19 away. We're 19 subscribers away from 77,600. Let's push our way to 77,600 if we can. That would be super to get there by the end of the show. So let's see. If you haven't hit the subscribe button, let's take care of that, and then take our like and subscribe poll. As always, there are serious cheaters. There's only 50 cheaters today. That's good. We already have 300 votes and only 247 likes. The idea is you like, subscribe, and then you come over and vote. Should the murder charge be dropped? Should the second-degree murder charge against Karen Reed be dropped? 0% of you say no, she should be behind bars already. Only 2% of you say no, she should be retried on all 3 charges. And 10% of you say yes, the murder charge should be dropped, but try her on the other ones. So count 1 and counts 3. Counts 2 and 3, I guess, not 1 and 3. One is the murder charge. So you count. I hate when my brain gets ahead of my mouth like that. Let's try that again. So drop charge 1, drop count 1, and try her on charges 2 and 3. But 87% of you say yes, the murder charge should be dropped, but also all charges should be dropped. 88% of you now. That's a lot. I don't know. I don't think so. That's not. I sit in the yes, they should drop the murder charge and possibly the third charge, but we'll talk about that in a little bit. But I think the murder charge should be dropped, and she should be tried on count 2 and or 3. That's where I say I think it's a bit extreme to dismiss all charges against her. But that's one of the things we're going to talk about here today. So hit the like and subscribe poll. We'll check back in an hour or so and see how it's looking. And Pro Farrier with the $10 super chat. Good morning, Jeff from Arizona. With all the crazy in the world, do you have any Maritime Mondays planned? Maritime Monday is back on the menu next Monday. We will be back in full Maritime Monday swing next Monday. So stay tuned for that. I don't know what we're going to do yet, but we're going to put together something. So Maritime Monday starts again next Monday. And thank you. Pro Farrier is an absolute good guy. We had some drinks together in Vegas. Had a good talk. It was quite awesome. We just happened to be there at exactly the same time, so it was kind of fun. Thank you so much, Pro Farrier. Appreciate that. All right, let's get into the news. Let's get into the news. Let's see. Sorry. Yeah, not feeling like going full Keemstar today. All right, one of the first pieces of news, one of the first news items we need to look at is you will recall that 3 jurors reportedly came forward and said that they had all unanimously agreed to acquit Karen Reed of the murder charge, the second-degree murder charge. One of them said that the first and the third counts were unanimously agreed to be not guilty. Another one just said the murder, and the third one I don't think was clear, but of course, the prosecution was denying. The Commonwealth was denying that. The prosecution was denying that. But since then, we haven't been chewing that bone, dog. Strawberry's in full bone chewing mode. So all that's Strawberry. If you don't know, I have 2 English bulldogs. They're both sitting here. One is snoring happily. Yoda is snoring happily, and Strawberry is happily chewing a bone very, very loudly next to me. And at the $100 super chat or gift amalgamation, the total sum gets to 100. We unlock the emotional support potato pig dog cam. So if we get there, we'll throw the dogs up on camera. This is what we're after here, though, right now. 4th Karen Reed juror confirms a unanimous not guilty on murder, attorneys say. 4th Karen Reed juror. So far, we're up to 1/3 of the jurors have come forward and said she was unanimously found not guilty on the murder charge. Well, Karen Reed's attorneys on Wednesday filed a new memo in support of dismissing 2 of 3 counts against her last week's mistrial. After her last week's mistrial, saying that a 4th juror has come forward claiming that the jury was in full agreement of not guilty on second-degree murder. The memo by Reed's attorney states that a 4th juror confirmed what they learned from 3 jurors since Judge Beverly Kanana had declared a mistrial on July 1st. On Monday, in a motion to dismiss 2 charges against Reed as prosecutors seek to retry her, her attorneys claimed that the jury agreed not guilty on 2 counts, but the judge failed to ask them before calling a mistrial. Well, in an affidavit filed Wednesday, attorney Alan Jackson wrote that he learned from juror D that many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on counts 1 and 3? No one ever asked about those counts. According to Jackson, the juror told Reed's attorney that part of his or her discomfort was that she knew that the jury had reached verdicts on 2 counts and that Karen Reed might be retried on those 2 counts. And, quote, that's just not right. The juror added, every one of us will agree and acknowledge that we found Karen Reed not guilty of count 1 and 3 because that's what happened, Jackson wrote. Mass Live was unable to verify the attorney's claims that the jury unanimously agreed on any of the charges. Well, of course you can't. In Wednesday's memo, the attorneys wrote that the 4th juror's disclosures completely confirm the veracity of the previously filed statements of 3 jurors days earlier. Attorneys again contend that Reed should be acquitted of second-degree murder and leaving the scene of a motor vehicle crash causing death. They also wrote that if not acquitted on those charges, they could be, okay, this is getting into the motion to dismiss, which I guess is good. This will summarize it here, so I don't have to re-summarize it later. I probably will because that's how my brain works, but this is sort of the gist of the motion that was filed by the defense to have the charges dismissed, or alternatively to bring the jurors in and question them, do a voir dire of the jury to get to the bottom of what happened. So they also wrote that if not acquitted on those charges, they should be dismissed in order to avoid double jeopardy protections under state and federal law. Jack Lew, a former Massachusetts judge, told Mass Live on Monday that he did not find the double jeopardy arguments very convincing and said he rejected lawyers' arguments because a valid verdict was not returned by jurors. Well, I found the prosecution's, the defense's motion to dismiss to be quite compelling. There was case law that they cited that said that the form of the verdict, it doesn't matter if boxes were checked. What mattered was the meeting of the minds. If all of them had unanimously agreed to fill out the forms, then she should still be considered not guilty, even though the forms were not filled out. And that's one thing I had a problem with. The problem happens in retrospect. Looking back, I see another way that Judge Bev failed. And that was saying, look at count number 1. If she is guilty, mark guilty. If she's not guilty, mark not guilty. Consider count 2. So if you find her guilty, fill it out. I think they were under the idea that they had to come to a unanimous decision on all 3 charges before they filled out the jury forms. I think they should have been told, you fill out each verdict form separately and independently of any other considerations. So even if you're hung up on one of them and you agree on the other 2, then you fill those out. Or if you're hung up on one, or if you're hung up on 2 and you agree on 1, fill out the one you agree on. And I think that's what should have been done, but it wasn't. So former Massachusetts judge, he didn't find them very convincing. I found them to be very, very convincing, those arguments. In a supplemental affidavit from Jackson filed Wednesday, he wrote that juror D reached out due to feeling uncomfortable with how the trial ended and said the last day was a whirlwind and that jurors were rushed out of the courtroom after the mistrial declaration. Following a brief meeting with the judge, the next thing they all knew, the jury was on the bus. Jackson wrote, she described the end of the trial as very confusing. The juror told Jackson that the jury discussed telling the judge they unanimously agreed on the verdict. Okay, yes, on the not guilty verdicts for counts 1 and 3, but they were not sure they were allowed to say so. The jury believed that they were compelled to come to a resolution on all counts before they could or should report verdicts on any of the counts, Jackson wrote. After discussion, the jury decided to inform the court that they were deadlocked and they expected they would get further instruction about the remaining decided counts thereafter. Juror D explained that he and she was confused and upset that such instructions never came. Reed's attorneys wrote in Monday's motion to dismiss that they began receiving unsolicited communications from 3 of the 12 deliberating jurors the day after the mistrial. Jurors told the attorneys in no uncertain terms that they had a firm 12-0 agreement that Reed was not guilty of counts 1 and 3. The hung jury, Jackson wrote, was a result of an impasse over the second count. Prosecutors charged Reed motor vehicle manslaughter while driving under the influence. A juror contacted Jackson on July 2, the day after the mistrial, who told him the second-degree murder trial was off the table for all jurors. And then we kind of go back down through here, but that's the gist of this news story. The fourth juror has come forward. And with regard to that juror coming forward, a supplemental affidavit was filed, and that's what I want to look at now. It's a very short one-page document. So we will bring up the affidavit, the supplemental affidavit that was submitted, and then we'll catch up on some of the chats. Let's see. Share the screen. Defense filing. All right. This is awkwardly done. Right. Here we go. I hope you can read that. It's kind of blurry and kind of small, but I don't think, yeah. Can we stretch it out? There we go. Does that help? This is an odd window. All right. Oh, no! Damn it. Damn it, boy. Stop it. Stop messing with that. And move it on over. All right. Damn it. I hate this thing. All right. I hope you can read it because I ain't I'm touching it, but I'm trying not to damage it. Yeah, this is just really, really bad. Defendant Karen Reed supplemental memorandum in support of her motion to dismiss. Now comes the defendant Karen Reed by and through undersigned counsel and hereby respectfully submits the supplemental memorandum in support of her motion to dismiss filed July 8th, 2024. As reflected, you have to get the holy words out first. You have to say the words. Sorry, I should with my right hand, but it was gripping my mouse. As reflected in the attached affidavit of Alan J. Jackson, a fourth deliberating juror, Juror D, has now confirmed that the jury reached not guilty verdicts on count 1 and count 3. Alan Jackson affidavit, paragraph 5. Once they were dismissed, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on count 1 and 3? No one ever asked about those counts. Juror D told counsel part of his or her discomfort was that they knew that the jury had reached verdict on 2 counts and Karen Reed might be retried on those 2 counts, and that's just not right. Paragraph 9, Juror D further stated that every one of us will agree and acknowledge that we found Karen Reed not guilty of counts 1 and 3 because that's what happened. Based on the attached affidavit and all the reasons set forth in the opening motion and the fact that the disclosures of Juror D completely confirm the veracity of the previously, in small, oh yes, okay, and of course, because it's a stupid way that thing was embedded, that's all we get. We don't, in the end, we'll say, we have to dismiss the charges. I don't have a copy of the actual memorandum. I do not have a copy of that. I could not find it quickly enough. But that's the deal. A fourth juror has come forward. A fourth juror has said that what the others said was true. That everything was agreed upon on counts 1 and 3. So what do we do here? There's 1/3 of the people, 1/3 of the jurors have now come forward and said that we agreed that she was not guilty of murder in the second degree and leaving the scene of an accident involving death. So what do we do? Do we dismiss it? I think we should. I really, really think that we should. But the Commonwealth has a different idea than me, of course. Let's hang on, do one thing here. There, sorry. Had an emergency work text come in that I just had to quickly respond to. Right, but before we get there, let's check out what you guys are saying here. Burning Sensation says, Jeff, how about a Maritime Monday with Sal of what's going on with shipping? I'm trying. I'm trying. And we got some other guest things I'm working on too, like part-time historian, things like that. Unhung here with a $5. I think the McAlberts need to be more thoroughly investigated. Clearly, the jury didn't believe State's theory. I think a lot of people need to be investigated. Oh yes. Whilst I'm enjoying my bourbon, lime, and Coke, you can get some merch on the merch side if you want. I don't get any money from the merch, by the way. I just do it at cost. So if anybody wants silly stuff like this, they can get it. John Gordon, judge is responsible for this. Very disappointed. I agree. I do agree with you on that. Thank you so much for the $2. And Tracy Fagan coming in with a $5. I watched the judge in the David Swift trial read out each charge and asked if there was a verdict, what the verdict was. Is that not common? Yeah, and if they're deadlocked, like I said, at least the way I'm familiar with it is it will be, okay, we are not deadlocked. We came to an agreement on this charge, this charge, this charge, and that charge. So these are all guilty or not guilty, but we're hung on this one. We're deadlocked on this one or these two charges. You wouldn't say we're deadlocked 10-1, 10-2, or 11-1, or 6-6. You would say we've come to a unanimous agreement on these charges, and these we haven't. But as I said, the Commonwealth, they have a different view of how things should go. David Sorensen says, Legal Vices, the form doesn't matter checkbox quote is from a case about whether actions by the judge amounted to an acquittal, not a jury. But it's the legal theory behind it is the same. And it's the form. And I actually do believe, I do not have it right here in front of me, but I do believe it was in a jury trial. Even if I'm wrong, it's still the idea. No, it was a jury trial. If not, I apologize, but I distinctly remember it being on a jury trial. I'm going to keep your message starred here, David Sorensen, and if you're still around at the end of the show, I will check on that. I will bring it up after we get through the stuff we got to talk about today, and provide further comment. But before we get to that, there's been two other developments before we get to the motion. One of them people may know about, one of them may not know about. So let's check this out. Well, as you know, right immediately after the trial, Trooper Proctor was rehomed, unfortunately not to a farm in Vermont, but somewhere else to do something else. He was basically suspended with pay pending the investigation. Well, the investigation happened, and Trooper Proctor, lead investigator in Karen Reed case, suspended without pay. Michael Proctor had already been relieved of duty and his police-issued cruiser, gun, and gear taken away following standard practice in such cases, but was still collecting a paycheck pending the hearing. Well, we had the hearing. Rip Shannon Doherty. She was so pretty. I miss her. Massachusetts State Trooper Michael Proctor, the lead investigator in the Karen Reed murder case, has been suspended without pay after a duty status hearing on Monday. Interim Police Superintendent Colonel John Mon. Colonel John Mon accepted the recommendations from the duty status hearing board, a body of 3 commissioned officers who heard evidence in the matter, according to a police representative. Proctor had publicly admitted to making unprofessional and regrettable comments about Reed. He only regretted it because he got busted. That's all. Regrettable comments about Reed during the investigation into the death of her boyfriend, Boston police officer John O'Keefe. The investigation led to Reed being charged with second-degree murder, manslaughter, and leaving a scene of personal injury and death, which she denies. Last week, after a 9-week trial, a mistrial was declared. Her lawyers claimed on Monday the jury had been ready to acquit her on 2 of the charges, including murder, but Proctor had already been relieved of duty and his police-issued cruiser, gun, and gear taken away following standard practice. Proctor made about $102,000 in base salary and over $35,000 in other pay in the last 2 years, according to publicly available payroll data. That's like $250,000 in the past 2 years this dude has raked in. So Damn. The internal affairs investigation into Proctor remained ongoing. A state police spokesman said Monday, while announcing Proctor's suspension, the department will issue a filing on each allegation, sustained, not sustained, exonerated, or unfounded, and relay the results to the state's post commission, which keeps police disciplinary records. In such investigations, if charges are found by investigators to be warranted, they are adjudicated by a state police trial board. Dun, dun, dun. A protest was scheduled to take place Monday afternoon outside the State Police Troop H barracks in South Boston, where Proctor had been reassigned from the Norfolk District Attorney's Office. The transfer did not make him eligible to work in Troop H. While Proctor testified during Reed's trial that he referred to the woman as a whack job. Oh, that's like the nicest thing he said to her. That's like the nicest thing he said to her was calling her. I don't think. Calling her a whack job. I can think of a few other more serious things, one of which was, and texted his sister, hopefully she kills herself. He insisted the comments had no bearing on the integrity of the investigation. Lie away, buddy. Proctor's comments prompted widespread outrage. Governor Maura Healey called the comments terrible and said they tarnished the integrity of law enforcement. Well, by gum, they did. Black Horse Cavalry lawyer math. It was 130. No, it was each year. If you look at the data, he made that each year. It wasn't very clearly written. I've seen other ones. See if we can womp that out. Hang on here. Nope. I stand corrected. Nope, I do not stand corrected. We'll show you here in a minute. Anyway, let's get back to the story. Scrolling on down. Okay. I think I've been very clear, and I want to be very clear. This conduct in any way, shape, or form in the Massachusetts State Police will not be tolerated, he said. More on Michael Proctor and Karen Reed. More style. Fine. But okay, before we get into the but.
Phrasing.
Damn it. Before we look at the next part of what I wanted to look at. Damn it. Let's look at Michael Proctor's pay records, shall we? Here's Michael Proctor's pay records. We probably need to undarken this so we can see it here. There we go. If we look at the year 2023, we see that his base pay in 2023 was $102,000, with overtime pay of $36,000 and other pay of $7,000. So he was up in the 36, 43, about the $145,000 in 2023. And then in 2022, it was almost, he made a little bit more in overtime pay and a little bit less in other pay. So roughly each year he made about $135,000, $140,000. 2024, he's made significantly less than that because we're only halfway through the year. But if you look at the average, he's on line to make just about the same. You can see his progression. He was making much less, but his salary has essentially gone up more than 25% in the last 7 years. So that's the article was not very clear. It was each year he made that much money. All right, let me darken this up again so we don't get the reflection off of my glasses. Well, now let's get into the exceptions here. But first, Island with a $2 super chat sent you the Juror D doc on Twitter DM. Well, thank you so much. We'll see if we can get to that by the end here. Thank you very much, Island. And Adam Wathen, what's up? I don't think I can listen to Adam Lally for another trial. Well, let's hope A, it doesn't get there, and B, if it does, he's not around. He's not doing the prosecution stuff. Thank you very, very much. Oh, and it looks like we are halfway to Doggo Cam. Cool. Brass Brass 6073, he has co-workers from his unit who were involved in the investigations of Turtle Boy and of the molestation and death of Sandra Birchmore, ruling Birchmore's death a self-deletion. And also another case that Hayden over at Aussie Overlord has been paying attention to, where a person with clear mental disabilities had, I believe it was a toy gun. They chased him down and blasted this guy 31 times. They pumped 31 rounds into this other guy. And you'll hear names like Lank, Proctor, and other people from the Karen Reed trial involved in that as well. And that's one of the things I hope to do and start doing in the next week or two, is looking into the Birchmore trial and the Moore, I think the guy's name is, and the other case. Right. So, as I was saying, we have an Aussie raid. Hey, Aussie, we were just talking about you. I don't know if you were here when we were talking about you, but we were just talking about the awesome work you are doing on the Birchmore and the other case. And Aussie's kicking it. Aussie is he's killing it with this third case. You need to definitely watch him and his discussions on that, because he's got an inside track and he's got a ton of cool stuff relating to the trial. So follow Aussie Overlord for that. I'm going to be riding his coattails and picking up the crumbs and seeing what I can glean from him as I go forward in the next couple of weeks to look at it. Emmanuel Quinones, what do you think about the Trump assassination attempt? Well, it's kind of off topic, but obviously it's a horrible, bad thing. Nobody, regardless of your political views, should be the object of an assassination attempt. That's just stupid. And thank God that he survived. Otherwise, there could very well have been Civil War II starting over that. Go to the polls, cast your votes that way. Don't cast your votes with bullets one way or the other. That's pretty much it, I guess. We'll talk more about it on Friday, during F Friday, when there's not another topic. And by then we should have a little bit more information about some of the stuff that's gone on surrounding it. We can talk all the conspiracy stuff. We can do all that. We can do all that on Friday. So let's table it and let's shelf it until then. But as I was saying, Proctor, he was originally suspended with pay. They had their little hearing. He's suspended without pay, pending the resolution of the full formal investigation. And there's some backblast from this. Thank you, Brass, for Canton, Norfolk. Check the name Craig Casey. That might be the one. That might be the one that Aussie's covering. I can't remember the guy's name, but if that's the guy they Swiss cheesed 31 times, that's the one that Hayden is looking very, very closely at, and I recommend everybody following him. Proctor not only didn't talk himself out of being suspended with pay, he drugged someone else down with him. He got somebody else in trouble. Justin Ritt. Okay. So Craig Casey's another one we have to look at again. Justin Root. Anyway. All right. So follow him for the Justin Root, and I'll look into the Craig thing too, the Craig Casey. All right. Thank you very much for that. Let's see. Who did Proctor bring down with him? Proctor, because of his testimony, apparently got someone else suspended. That someone else just happened to be, she's a crazy looking woman. Canton police put Brian Albert's brother, Kevin, on leave following Karen Reed trial testimony. All right, why is it doing that? There we go. More fallout from the Karen Reed case is building in Canton, Massachusetts. News 10 learned that Canton police officer Kevin Albert was placed on administrative leave last month. He is the brother of Brian Albert, who hosted a party at the home where John O'Keefe was found unresponsive in the snow. He's also the brother of Chris Albert, who serves on the Canton Select Board. The chair of the Select Board said Kevin Albert was placed on leave due to his actions in the case he investigated with Massachusetts State Police Trooper Michael Proctor 2 years ago. Proctor, the lead investigator in the Karen Reed case, was suspended without pay. During the trial, he admitted to partying with Albert in 2022, months into the Reed investigation. Tuesday night, things got heated at a Canton Select Board meeting, with many residents feeling like the damage to the town has already been done. The chair of the Select Board said Albert has been on paid leave since June 13th and will remain on leave until the investigation from an independent review is completed. Proctor's testimony about Albert, says the comment, came just one day earlier on June 12th. And if you read other articles about it, there are articles that say the decision to suspend Kevin Albert and subject him to the internal investigation was due to testimony given by Proctor during Proctor's internal hearing on this, related presumably to the partying they were doing together months into the investigation. Well, that brings us up to date on the news side of things. We do have, okay, Brass, we already got you there. Sorry. You almost got a twofer. See, sometimes if I'm not paying attention, you get a twofer on the super chat. So we almost gave you one. Okay, all right, let's see. Checking to see what else is going on here in chat. All right. Looks like nothing. Would it ever be okay for the state to come back after a mistrial if a juror said they found guilt on 1 and 3, but deadlocked on number 2? Not sure exactly what you're asking. Would it ever be okay for the state to come back after a mistrial if a juror said they found guilt on 1 and 3 and deadlocked on 2? That's an interesting question. I would say no, they couldn't go, never mind, they found you guilty, you have to come to jail. I don't know the exact legal reasoning behind it, but my gut tells me no. That's interesting. Ooh, what an interesting question. I like that. Ooh, I'm good. All right, let me type this out. That's food for thought. This trial, if a juror said they found guilt on 1 and 3, but deadlocked on 2. Ooh, thank you. Damn it, Adam Holbrook, stop making me think at 10:46 p.m. Jeremiah Jordan, what will be the next trial you cover? YNW Melly 2.0? No. No, it will not be YNW Melly. For those of you, some of you saw my Twitter post where I said, oh my gosh, the judge has finally set a date for the retrial of YNW Melly. He was acquitted a year ago, and they were supposed to restart the trial in October of last year. They were getting the jury all set up, and they were starting the first batch of voir dire of the jurors, and there was a big problem. And they had to dismiss all of the jurors and start over again. Then the prosecution wanted to put in some of his lyrics. He objected, and then now it's on an appeal to the Supreme Court, and nothing is going to happen until the Supreme Court makes their decision on whether or not this can come in as evidence. But I saw that they'd set a date, and I'm like, oh my God, they set a date for September 20th. And so I said, yay, they set a date for September 20th. The problem is, I looked at it again, September 20th, 2025. So yeah, Karen Reed probably has a better chance of going on trial before YNW Melly. The next case probably be Sarah Boone. Hopefully that October date will stick. But anyway, I'll let you know what it is. There might be some smaller stuff we do in the meantime, just for giggles. But the next big trial will be Sarah Boone, most likely. And then hopefully Courtney Clenny will go on trial sometime in the near future, but we'll see. All right. With that out of the way, let's look at what the Commonwealth, what did the Commonwealth have to say about the defense's motion to dismiss? The defense made their motion. I thought it was very, very compelling, but apparently other people have different opinions, and I would like to know your opinion here. Once we wrap this up, let me know what your thoughts are and why. How are we doing on time? Okay, I was just waiting to see if we needed to check back on our like and subscribe poll. Not yet. We still check back in 15, 20 minutes. All right, let's bring up the PDF. Winders. There's the Winders. Sorry, I just settled a huge case today, and everybody's wondering what the hell's going on. So occasionally, I might have to stop to make a couple of texts. Like a $5.2 million settlement, so people are interested in it. I want to forget about it so I can relax and chill with you guys, but they pay bills. Karen Reed. Commonwealth v. Karen Reed, Norfolk Superior Court, docket number, yada, yada, yada. This was filed July 12th. This was filed last Friday. I can't see the timestamp. It looks like 11:20 a.m. Yeah, it looks like about that. July 12th, a.m., 11:20 something. Anywho, that's not the important part. The time isn't important. It's just, it was filed last Friday. So it's new, it's hot off the presses, and that's as big as we're going to get it. That's what she said. This is a long document, so. Yep. Okay. Commonwealth v. Karen Reed. The Commonwealth's opposition to defendant's post-trial motion to dismiss. Now, again, we have to say the holy words, the holy boilerplate. We have to worship at the altar of the holy legal boilerplate wording. Now comes the Commonwealth in opposition to the defendant's post-trial motion to dismiss her indictments for second-degree murder and leaving the scene after causing death, and the defendant's motion is premised upon hearsay, conjecture, and legally inappropriate reliance on subjective jury deliberations. Okay, let's say that a little bit slower. Here comes the Commonwealth. I'm going to come. Now comes the Commonwealth in opposition to the defendant's post-trial motion to dismiss her indictment for second-degree murder and leaving the scene of death. Why? The defendant's motion is premised upon hearsay, conjecture, and legally inappropriate reliance as to the substance of jury deliberations. You can't, you're sort of not allowed to go and look at the interior workings of jury deliberations. With their reasoning, their rationale, whatever it is sacred and sacrosanct. You can look at their results, but not not what was going on behind the results. Their deliberative process and all of that is sacrosanct. Further, contrary to the defendant's claims, throughout jury deliberations, the defendant was given a full opportunity to be heard. The jury's communications to the court explicitly indicated an impasse on all charges. The court explicitly indicated an impasse. See, this is interesting. The jury's communication explicitly indicated an impasse on all charges. I don't know that it did. She read it and they just said, we have reached a deadlock. They didn't say a deadlock on all charges, but all right, let's continue. Indicated an impasse on all charges, and the court carefully considered alternatives before declaring a mistrial. The defendant's unsubstantiated but sensational post-trial claim that the, quote, jury reached a unanimous decision to acquit lacks any merit or legal foundation. On June 9th, 2022, the defendant was indicted by a Norfolk grand jury for second-degree murder. In violation of manslaughter while operating under the influence, in violation of, and leaving the scene of a personal injury / death, in violation of. On April 16th, 2024, a 10-week jury trial commenced With Judge Bev, the jury began their deliberations on June 25, 2024. In addition to the 3 indictments, the jury was instructed to consider 2 lesser included offenses to manslaughter while operating under the influence. 1, involuntary manslaughter, and 2, motor vehicle homicide, operating under the influence of liquor and negligence in violation. Before too long, I'm going to be operating under the influence of liquor. The defendant's motion states that the court's decision to declare a mistrial was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. Yet, the defendant's motion and supporting affidavits of counsel inexplicably omit the full opportunity that the defendant was given to be heard and the defendant's consent to the mistrial. All right, I'm curious to see what the defendant's consent to a mistrial could be, because the defense was saying we didn't consent to a mistrial. Beginning on Friday, June 28, 2024, at approximately 12:15 p.m., the jury sent a note stating, "I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict." Okay. So this is the first one. Nothing there says what charges. Nothing there says plural. All right. At that time, the court requested argument from the Commonwealth and defendants as to whether the jury had engaged in due and thorough deliberations. Commonwealth responded that the jury had not had sufficient time to deliberate and requested that the jury be instructed to continue their deliberations. On the contrary, Attorney Yannetti argued, "We believe there has been sufficient time," and advocated for the jury to be declared deadlocked and provided the Tuy Rodriguez instruction. Okay, all right, we'll read this in just a second. I guess this is a good time as any. Failure of jury to agree states that if a jury, after due and thorough deliberations, returns to the court without having reached a verdict, the court may state anew the evidence or any part of the evidence, explain to them anew the law applicable to the case, and then send them out for further deliberation. But if they return a second time without having agreed on a verdict, they shall not be sent out again without their own consent unless they ask from the court some further explanation of the law. Trial transcripts are not available yet. However, the trial was widely broadcast across national media. Attorney Yannetti's statements are available for view at, here's your link. Okay. Fine. Let's continue. Attorney Yannetti stated, "The word exhaustive is the word I think is operative here. They're communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and they are at an impasse. You know, this is a case where the jury has the legal instructions. They've only really asked one question, which was to get a report that they were not allowed to get, and I think the message has been received that the evidence is closed and they won't be getting anything more. They've been working essentially nonstop for the last 3-4 days, and we're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is the jury should be read the Tuy Rodriguez model instructions to go from there." The instructions is for us. That's what they call the nuclear option. That's where you go, look, you think she's guilty. There are people that disagree with you. Perhaps you're being unreasonable in your view that she's guilty. Why don't you try to look at it from his side of view or her side of the view? And you think they're not guilty, but here's some people that are really convinced. So perhaps you should look at them. Perhaps you're being unreasonable in your definition of reasonableness. Basically saying, look at it from the other side and come back again with a verdict. And it's called the nuclear option because it's a little bit spicy that you're telling everybody to stop being so bullheaded and try to look at it from the other side. Plus, if they come back again, it's an automatic, you pull the ripcord and they're done, unless you ask them very nicely and they agree to do it. You can't order them to go back again for deliberations if they come back after the Tuy Rodriguez instruction. So it's instructions for where after due deliberation, the jury has expressed that they are at an impasse. The Tui Rodriguez has a certain sting to it. And they use spice, they use sting. A Tui Rodriguez, spit on that thing. Instruction should not be employed prematurely or indiscriminately. The court ruled that given the length of the trial, number of exhibits, and complex issues in the case, there had not been due and thorough deliberations and instructed the jury to continue deliberating. Well, Monday rolls around. On Monday, July 1, 2024, at approximately 10:45 a.m., the jury sent another note to the court stating, Judge Cannon, despite our commitment to the duty entrusted in us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in lack of understanding or lack of effort, but deeply held convictions that each of us carry, ultimately leading to the point where consensus is unattainable. We recognize the weight of this admission and the implication it holds. Following receipt of that note, the court again inquired of the Commonwealth and defendants as to whether there had been due and thorough deliberations. The Commonwealth argued that although the jury had been deliberating approximately 22 hours, given the length of the trial and number of witnesses, the jury had yet to engage in thorough deliberations. So the Commonwealth, they admit that they said, look, they've been going for 22 hours. That's nearly 4 days. 3 days anyway. Nearly 3 full days of trial, of court time. But they haven't really been considering it hard enough, so they should go back and do more. And on the other side, Attorney Yannetti again sought a Tui Rodriguez instruction stating that the jury has come back twice, indicating essentially that they're hopelessly deadlocked. They said they've been over all the evidence. At this time, they say they have fundamental disagreements about what the evidence means. It's a matter of opinion, not a matter of lack of understanding. Footnote 3, counsel's argument is available. Okay, I don't need to see that. The court found that at this point, the jury had engaged in due and thorough deliberations, noting that this has been an extraordinary jury. The court indicated it had never seen a note like this reporting to be at an impasse. So at approximately 11 a.m. on July 1st, 2024, the jury was advised of the full Tui Rodriguez spit on that thing instruction, including that it was the jury's, quote, duty to decide the case if you can do so conscientiously, and that there is no reason to believe another jury would be more competent to decide this case. On July 1st, 2024, at approximately 2:30 p.m., the jury sent a final note to the court stating, and I think this might be important. Why I think this might be important is because Dave Sorensen said, charges, I'm not going to say all charges was explicit, but charges in the plural was used. You're talking about my like and subscribe poll, I guess. Which at this point, 2% say no, she should be tried. Should the murder charge be dropped? 2% say no, she should be tried on all the counts. 2% also say no, she should be behind bars already now. 13% say yes, the murder charge should be dropped, but try her on the other ones, which would be the vehicular manslaughter and the leaving the scene of an accident involving death. And 82% of you said yes, all charges should be dropped. I think that's a little harsh, but 82% of you say that. But I'm saying, let's see what the wording of this letter is. This letter from the jury, this note from the jury. Does it imply that they were deadlocked on all of the charges or only some of them? I think the wording is important, and I can't remember what the exact wording was. So let's look at it. Despite our rigorous efforts, we continue to find ourselves at an impasse. Okay. Our perspectives on the evidence are starkly divided. Okay, it doesn't say divided on how many charges. Some members of the jury firmly believe that the evidence surpasses the burden of proof establishing the elements of the charges beyond reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. Following the receipt of this note, the court discharged the jury and declared a mistrial. Okay. Well, the note does say establishing the elements of the charges, but so that could imply one of two things. It could mean there's a disagreement on whether the burden of proof hasn't been met, or what they're deadlocked on count 1, count 2, and count 3. Or it could also mean that they were unanimous on count 1, not guilty on murder. They were unanimous on count 3, which is leaving the scene of an accident involving injury and death. And it could mean they're completely in agreement, unanimously agreeing that which count 1 and count 3 are not guilty, but count 2 had 3 charges in it. So if we're looking at the exact wording, if we're going to be pedantic about this, there weren't 3 charges. There were 3 counts. Count 2 had 3 charges within it. It had the main charge, the lesser included, and the lesser included charge. So if they would have come back and said, proving the elements of the counts beyond reasonable doubt, I would probably be a little more skeptical. But on this, I would say, especially if we look at what the 4 jurors, 1/3 of the jury has now come forward and said, I think it means that they were unanimous on counts 1 and count 3, but they were at an impasse on the 3 charges inside count number 2. Hey, legally minded friends, Karen Cole, how you been? It's been a minute. Haven't seen you here for a while. Hope you're doing great. Thank you so much for being here. Exactly 100%, Jeff. Very confusing. Judge should have asked, what can you agree on? Yeah, that's a very natural, very logical question. What charge? What are you deadlocked on? What counts? What charges are you deadlocked on? If they say all, okay. If they say on one of them, okay, it would be very, very clear. It was very, very easy. And this was very, very rushed by any accounts. All right, I'm not going to do this. We're not going to do this anymore. Okay, we're done. I'm going to declare a mistrial, jury. Get out of here. We'll talk to you later. That was very, very, it was suspiciously rushed. And I don't like suspicion. I'm not a conspiracy theory guy by and large, that everybody's corrupt and everybody's trying to do this, but she did rush them out. Normally, you would get the jurors. You guys have been real troopers. You did a great job. You tried your best. I know you couldn't. You come to a decision, but by gosh, you guys gave it a real good try. You don't have to. And then she should go through you're now hereby released from jury duty. You don't have to. You can talk to anybody you want to. You can't be compelled to. She didn't do any of that. She's just like, all right, mistrial, get out of here. Jury, you're on your way. I'll come and talk to you a little bit later. Bye. And that was it. It was suspiciously quick. Aussie Overlord has said, is more than that. There's a Massachusetts court rule and ABA rule that says she should have asked. Yeah, that was part of the motion to dismiss, was that she should have asked and she didn't. Well, let's continue with the arguments here. In the motion. Jeff, will you propose to see Winter Storm for me? I'm not getting involved in any of that multiple shenanigan stuff. Apparently, it doesn't work out too well. So, yeah, I'm not getting involved in that. Y'all work that out between your two selves. Got to ask, if Proctor makes $122,000 plus $36K each year, why the fuck is he living in the shit shack? Cost of living must be pretty damn high. Anywho, jumping right back into this, I think this means that they were deadlocked on the 3 charges. It says charges, not count. And this seems to be a very, very articulate person who is writing this. So words mean things at this point. Yeah, so to me, it would indicate, especially in light of, I said, of 1/3 of the jury, 4 of them now coming forward and saying they were deadlocked only on number 2. It would seem to imply that it was the charges within count 2 that they were deadlocked on. All right. Well, here's where we get into the problemos. The representations made in counsel's affidavit have no legal bearing on the mistrial, as the jury did not reach any verdicts, partial or otherwise. A juvenile v. Commonwealth, verdicts must be reported in open court. The only verdict which can be received and regarded as a complete and valid verdict of a jury, upon which a judgment can be rendered, is an open and public verdict, given in and assented to in open court as the unanimous act of the jury, and affirmed and entered of record in the presence and under the sanction of the court. Okay. I'm just kind of analyzing this here on the fly, seeing if I can find any loopholes in it. It's an older case. It's 1984, so it's been around for a while. So they're saying it has to be out in open court and a public verdict. Well, she didn't ask if they'd come to any agreement on any of the charges. She didn't ask if they'd come to a verdict on any of the charges. Well, exactly, Jeff K. How do they say that in open court if not asked? I tend to agree with that, and that's what at least 2 of the 4 jurors said, that they were expecting to be asked. They didn't know if they were allowed to put it in their note, so they were holding on to it, expecting to be asked. But this is compelling. It depends on which side you're looking at. This is a pretty solid statement from this case of a juvenile v. Commonwealth. Well, there's also Lawrence v. Stearns and Commonwealth v. Tobin. The verdict which determines the right of the parties and is admitted of record and upon which judgment is rendered is the verdict received from the lips of the foreman in open court. Well, what if he had a verdict and he wasn't allowed to give it, or he or she wasn't allowed to give it? It's not enough to show the jury may have agreed on some issues at some time. If that limited showing were to control, uncertainties would be invited. Now, this I disagree with. I think this is obfuscating it a little bit. It's not that they had agreed on some issues. It had nothing to do with agreement on issues. They said they reached a unanimous verdict on murder charges, on the entire charge of second-degree murder. That's not some issues at some time. That is a unanimous verdict on one count of the crime, of one of the crimes she's been charged with. So I don't like the way this wording is used. That's my opinion. I think this part here, I need to get potentially Criminal Sean's telestrator stuff here. But yeah, this part I don't like. It's not enough to show the jury may have agreed on some issues at some point. They didn't come in and say, we agreed on some issues at some point. They said all 12 of us said she's not guilty of murder. We just weren't allowed to tell the court. No error in the judge's refusal to accept the not guilty verdict slips found in the jury deliberation room after the jury was discharged where those slips were in contradiction to the jury's report to the judge in open court that they were deadlocked. That's interesting. I'm going to have to look at this case. I'm very curious about this case suddenly. No error in the judge's refusal to accept the not guilty verdict slips in the jury deliberation room after the jury was discharged, where those slips were in contradiction to the jury's report to the judge in open court that they were deadlocked. Okay. I don't know. I'll have to check the facts of this case. I'll have to read this case. But here it could be, and I have no idea why, or no idea whether this is the deal, but it could be a situation where they filled out some of the forms and then said we're deadlocked for whatever reason in contradiction to the forms. But we're not certain in this case that there was a contradiction. Because one, we don't have the jury slips, but there is the case law cited by Jackson saying that just because it's not written doesn't mean that it's not a verdict. But they just said they were deadlocked. They didn't say what charges they were deadlocked on. So I don't know. It's Lally's got some compelling arguments too here. Legal-minded friends Karen Cole says in that case they are referring to had a verdict. Reed's didn't have a verdict. 100%, Jeff. Well, see that if this case, I haven't read the A Juvenile v Commonwealth, but if they all had jury slips marked not guilty on all charges or whatever the charges were, why would they come back and say they were deadlocked? And I don't know. Interesting. Something bleeped on my computer and I have no idea what it was. The hearsay comments and juror statements about what happened are legally irrelevant, as the jury failed to reach any verdicts. Oh, see, this is interesting. See Bluford v. Arkansas. The Commonwealth here is quoting Bluford v. Arkansas, but the defense also. My VPN. I have a VPN going. Why do I have a VPN going? All right, I'm going to do something I've never done before. I am going to turn off my VPN. If something happens, don't panic. I'll be right back. Hello. Something did happen when I turned off my VPN. Cool. All right. It's like nothing happened, and then suddenly it goes blank. It did happen. I'm back. No, I'm here. I'm here. Don't panic, people. The law Rex prevails. I'm like Donald Trump. You can't assassinate my stream, bitches. All right. Anyway, as I was saying, the Commonwealth is quoting Bluford v. Arkansas here, but also the defense quoted Bluford v. Arkansas twice in their motion to dismiss. So this is dueling interpretations of the same case. I love that kind of stuff when both sides are arguing that the case says something completely different. That's cool. So in Bluford, the jury sent a note to the court indicating that they were hopelessly deadlocked. And the court asked the foreperson to disclose the jury votes on the 3 charges: first-degree murder, manslaughter, negligent homicide. Okay. The foreperson reported the jury unanimously agreed the defendant was not guilty of murder, but were deadlocked on manslaughter and had not voted on negligent homicide. The court gave the jury an Allen instruction, which is akin to the Tui-Rodriguez instruction, that emphasized the importance of reaching a verdict and instructed the jury to continue deliberations. Okay, that sounds pretty factually similar to what we have in this case. After a half hour, the jury reported they had not reached a verdict and a mistrial was declared. All right. The United States Supreme Court rebuffed the defendant's claim that the jury acquitted him of murder, as the four-persons report was not a final verdict because the jury had continued to deliberate and, more importantly, gave no indication that there were still unanimous on the murder charge. I'm not liking that one. I'm not liking the wording of that too much. So they reached a unanimous verdict of not guilty on the murder charge. Then they sent them back to continue their deliberations on the other two charges. Then they came back and said, we're deadlocked. And the court said that because they didn't say they were still unanimous on the murder charge, there wasn't a verdict reached. If they've already reached a unanimous decision, why would they continue deliberating it? I would assume that if they reach a unanimous verdict, at that point, it's a done deal. But all right, well, the Supreme Court is smarter than me sometimes. So not all the time, but sometimes. All right, the United States Supreme Court emphasized that when jurors engage in discussions about the circumstances of the crime, it often causes one to rethink their stance on a greater offense and revisit a prior vote. The very object of the jury system, after all, is to secure unanimity by a comparison of views and by arguments among the jurors themselves. A single juror's change of mind is all it takes to require the jury to reconsider the greater offense. Well, I don't see any indication. Maybe there was in the Buford or whatever the hell this case is, Bloomfield, Bluford. Maybe there was, but I don't see any indication that anybody ever reconsidered the prior vote on the greater charges. So why would we assume that happened or might have happened? Why wouldn't we assume that there were no changes in a position on a greater offense unless the jury gives some indication? A Tui-Rodriguez instruction is designed to urge the jury to reach a verdict by giving more serious consideration to opposing points of view. It must be recognized as a practical matter that jury votes on included offenses may be the result of temporary compromise in order to reach unanimity. Yes, that happens. A jury should not be precluded from reconsidering a previous vote on any issue, and the weight of final adjudication should not be given to any jury action that is not returned in a final verdict. A jury should not be precluded from reconsidering, and the weight of final adjudication should not be given to any jury action that is not returned in a final verdict. This whole thing is, again, predicated on the fact that there's a supposition that they only reached unanimity as some sort of temporary compromise. That doesn't seem to be the case here. Again, food for thought. The jury's notes were ambiguous that the jurors were unambiguous. The jury's notes were unambiguous that the jurors were deeply divided by fundamental differences in our opinions and state of mind. that resulted in a starkly divided jury as to the charges. Emphasis on plural again. Is it counts or charges they're referring to? There's no clarification. This is where I think this is a bit weak. Is it the 3 charges inside the second count, or are they using count colloquially they're using charges colloquially to refer to the charges as counts? I mean, the counts as charges. You know what I mean. It's even confusing me. And again, whoever's writing these notes is very, very precise. The jury consistently indicated that their impasse was not due to a lack of understanding of the law or the charges, but a profound divergence in deeply held convictions, ultimately leading to a point where consensus is unattainable. The jury notes did not indicate agreement on acquittal on any of the charges. Well, that we have the affidavit saying that they didn't know if they should, and they were expecting, so they decided not to, and they were expecting the judge to ask them. All right. The jury's notes did not indicate agreement or acquittal on any of the charges. Rather, it was evident that the jury was unable to agree on any charges due to their sincere adherence. No, that's a step too far. They didn't indicate agreement or acquittal on any of the charges. I can maybe squint my eyes and go, okay, I can accept that, because it doesn't. The notes did not specifically indicate an agreement, but rather it was evident the jury was unable to agree on any charges due to their sincerity. Now, there's nothing in there that says they were unable to agree on any of the charges. That's a step too far in this argument, I think. Due to their sincere adherence to their individual principles and moral convictions. Contrary to representations made in the defendant's motion and supporting affidavits, the defendant advocated for and consented to a mistrial. Advocated for and consented to a mistrial as she had adequate opportunities to object and instead remained silent, which removes any double jeopardy bar to retrial. So they're saying by remaining silent, she advocated for a mistrial. Well, the defendant in the motion said that they weren't given adequate time or opportunity to state their objection. It's not that they'd remained silent; it's just that they didn't have time to object. All right, so this is an interesting argument. Commonwealth v. Fetsaya, consent to a mistrial may be inferred from silence, where a defendant had the opportunity to object and failed to do so. I can see there's going to be a little bit of argument on whether or not they had the opportunity to object. She was like, okay, here's this deal, and all right, I'm not gonna submit them any more of this. They're gone. Mistrial, bye. Did the defendant have the opportunity to object and failed to do so? Interesting. Consent to a mistrial may be inferred from silence, where the defendant had the opportunity to object and failed to do so. And Daniels v. Commonwealth, where defense counsel told the judge he believed the jury was at an impasse in deliberations. Defense counsel told the judge he believed the jury was at an impasse in deliberations and had no objection to the judge declaring a mistrial. Such consent removed any double jeopardy bar to retrial. That's distinguishable from this case. Despite having an adequate opportunity to object, again, what is an adequate opportunity to object? Is it a second? Is it 10 minutes? Somewhere in between? What is an adequate opportunity to object? I think that's going to become an important issue in this. Despite having an adequate opportunity to object, defense counsel remained silent, proper to infer from counsel's conduct that defendant consented to the mistrial. See also Commonwealth v. Coitus, 53 Mass Ab. The manifest necessity test has no application in situations where, as here, the defendant requested or effectively consented to a mistrial. Okay, the defendant did not request a mistrial. As far as effectively consented, again, what is adequate opportunity to object? It's little questions like that. What does adequate opportunity to object mean that keeps lawyers in business? We can argue for eons about what adequate opportunity to object means. During her full opportunities to be heard on June 28th, 2024 and July 1st, 2024, at no time did any of the defendant's 3 counsels request inquiry as to what charge or charges the jury was deadlocked on. Rather, the defendant was quick to request a Tui Rodriguez instruction of first opportunity, indicating a belief based on the clear and obvious language of the jury's notes that, as stated by Attorney Yannetti, the jury was hopelessly deadlocked and exhausted all manner of compromise and was engaged in fundamental disagreements of what the evidence means. It's a matter of opinion. It's not a matter of understanding. Okay, I actually think this is a fairly good argument that Lally's making right here. So he's saying that the notes came back and said that they're deadlocked and all of this, and Yannetti was arguing that they're hopelessly deadlocked. They're exigent all manner. It's clear that he wanted these instructions to be read and them to come back and say we're deadlocked, and for a mistrial to be declared. I think this has some teeth. This particular argument has a little bit of teeth. Clearly, Yannetti was very, very anxious to get the Tui Rodriguez instructions in, and presumably because he thought they're deadlocked on all the charges, and he wanted it out of there. He wanted a mistrial so that Karen Reed was guaranteed not going to jail that day. So I think this is an interesting one. That's an interesting part of the argument, to me anyway. Where are we at here? Counsel's request for a Tui Rodriguez instruction permits the inference that both parties were provided an opportunity to be heard on possible alternatives to a mistrial. The timing of a Tui Rodriguez charge is committed to the discretion of the trial judge. Once a Tui Rodriguez instruction is given, the jury could not be sent out again to continue deliberations without their consent. Now, furthermore, following the discharge of the jury, the court engaged the Commonwealth and defendant in discussions about choosing a status date for scheduling a retrial. At no time during that hearing did the defendant object or indicate displeasure with the mistrial. Okay, that strikes me as a pretty compelling argument. So the defense is arguing they didn't have an opportunity to object because she shut it down and ran them out. But then they did stick around and discuss the status hearing. And as is pointed out here, the defense didn't say, hey, what the hell was that, Judge? What are you running us out of here? I object to that. I object to the way you handled that. Deb Peterson asked, could the defense have requested that the jury be polled on all counts? Normally, you're only allowed to poll a jury on a verdict, and a deadlocked or hung jury is not a verdict. So normally you wouldn't be allowed to do that. I mean, the judge could, I guess, ask if they wanted to. What are you deadlocked on and what aren't you deadlocked on? But as far as going each individual juror saying what did you think on each and every one of these counts? Probably not. But again, I don't know. I'm not a Massachusetts lawyer. I have no idea. But generally, I would say no. The mistrial was also supported by a manifest necessity jury deadlock. See Commonwealth v. Bryan. In considering whether to declare a mistrial over a defendant's objection, the court must give the counsel a full opportunity to be heard and careful consideration to alternative to a mistrial. A frequent and traditional example of manifest necessity to declare a mistrial is where the jury were discharged because they were unable to come to an agreement on a verdict. Thames v. Commonwealth. Mistrial warranted where jury reported inability to reach decision after 4.5 hours of deliberation, during which the jury twice sent judges messages about impasse and judge inquired about jury's ability to reach agreement. Okay, well, the judge inquired about the jury's ability to reach an agreement. The judge in this case, Bev, did not inquire about the jury's ability to reach an agreement. She didn't say, are you deadlocked on everything or only one of the counts or a couple of the charges within count 2? She didn't ask any of those questions. She didn't ask, okay, is this something you think you can work out? Have we come to an agreement on any of the charges? So I think this is distinguishable. This case, I believe, is distinguishable. Describing hung jury as a prototypical example of manifest necessity. Mistrial warranted where jury reported deadlock on the 4th day of deliberations after jury inquired about the inability to reach a verdict. The trial judge is best situated to determine whether the ends of substantial justice cannot be attained without discontinuing the trial. Commonwealth Cassidy, Gorey v. U.S. In declaring a mistrial, premised upon the trial judge's belief that the jury is unable to reach a verdict, the decision is treated with great deference. That's important wording here. We'll get back to that. Because otherwise, must be treated with great deference. Otherwise, there would be danger that the judge would employ coercive means to break the apparent deadlock. Well, the decision of the judge that the jury has reached an impasse or that they're unable to reach a decision should be treated with great deference. It doesn't mean you must absolutely concur with the judge. It doesn't mean you absolutely have to follow the judge. It just means you should give a lot of weight to the judge's determination that the jury seems unable to reach a verdict. Deadlocked juries are particularly susceptible to coercion. The term manifest necessity is another way of saying that in a particular case, the right of the defendant must yield to that of the public. Trial judge interacts directly with jurors and is in best position to determine whether the jury is deadlocked. Again, you should give a lot of weight to what the jury determines, but it says a lot of weight. It doesn't say absolutely must bow down to it. Right. This is fascinating. So far, we're 10 pages into the 15-page document. Let's all take a breath here. Let's take a little bit of a breather. I am finding this very, very fascinating. And I want to hear your thoughts on this. What I see here is, I think the Commonwealth's arguments were very, very sound. I think they were quite solid. The arguments being made here by the Commonwealth, did I say Commonwealth? I found the defense's arguments to be very, very solid, very persuasive. And here, the Commonwealth, although there are parts I have problems with, I must admit, I find some of their arguments to be very persuasive as well. I want to know what you guys think about this. Oh my gosh, D What in the house. D What with the bell here.
For a bad court thing.
Hey, that's not
a mistrial? Yeah.
That would be that's an oddly correct incorrect sound. This was the sound that was played.
I move for a bad court thingy. You mean a mistrial? Yeah.
But I was trying to give him the bell for the 5 memberships. But weirdly, we accidentally did a mistrial. D What has gifted 5 Legal Vices memberships. If you happen to be Porcelain Thunder, Sleuthy Goosey, Gabby and Mara, Twisted Life, and Great Success, make sure you give D What a super special thanks. Congratulations to Great Success, Twisted Life, Gabby and Mara, Sleuthy Goosey, and Porcelain Thunder. And thank you from the bottom of my cold, dark, dead heart. Thank you, D What, for the gifted memberships. Now I have to do lawyer math. Okay, we're about 3/4 of the way to Doggo Cam here. If anybody's keeping score at home. All right. So again, as I was saying, what do you guys think about this? Are you persuaded by what you've seen so far from the Commonwealth in their objections? Do you think that they've persuaded you that this mistrial is a mistrial and the charges shouldn't be dismissed? Catherine, what bothers me is as the Commonwealth, they're supposed to be for finding the truth. Here they're trying to bury it. Okay. I don't think Lally wrote this motion. I didn't see what if questions or statements. Well, okay, let's assume he wrote it. What's your feelings on this motion? Because I'm still more persuaded by the defense's arguments, but I'm not persuaded by the Commonwealth's motion. I find it quite compelling in a lot of ways. No, Jeff, the investigation. I'm just talking about the arguments. You have to look at the legal merits of the arguments. Which one legally persuades you? Because the fact finding is done. So I mean, as far as the first trial goes, we're not going to be able to introduce new facts until this gets sorted out. Ask the jury. Yeah, well, that's what there was the defense's motion, and that's where I'm kind of going with this. I'll give you a little view into future, Jeff. The motion to dismiss was the motion to dismiss counts 1 and 3, or at very least to bring the jurors in and voir dire them on the issues at hand and let the judge see that. So that's where I'm going. I was incredibly persuaded by the defense's motion. Now I'm starting to lean towards maybe we should just bring the jurors in and let the jurors give their thoughts, opinions on what happened and go from there. So that's kind of where I'm sitting now. And Sonny or Chris, not to be overshadowed by D. What, Sonny or Chris has said, hey, I'm giving you 5 Legal Vices memberships too. It's a Legal Vices membership war. It's a battle for memberships. So far, it's tied at 5 memberships apiece. Who is going to be the membership gifting king of the night? Will it be Sonny or Chris, or will it be D. What? But in any event, we have reached that very, very special time of night, which we like to call
Release the hose.
And we're bringing in my little old buddies here, Strawberry and Yoda. Let's see if we can get them both in here. All right, there they are. They're just sleeping in their normal positions. All right, Sonny or Chris, if you happen to, thank you very much, by the way. SC or C, yeah, SC. There. Jason J. Xterra Bill, congrats, Xterra Bill. You got one. John Sellers got one. Criminal Mad got one, and Kimberly Woodson got one of the 5 gifted memberships. So there you have it. Sonny or Chris, give them a super special thanks. D. What? Sonny or Chris, neck and neck in their giftathon to see who will be the gifter of the night. All right. We've unlocked Doggo Cam. That's the important thing. So, all right. As I'm saying, I'm starting to be persuaded that maybe it's a little premature to just dismiss the charges. Maybe we should see what the jury has to say. But let's continue, shall we? The court engaged in considerable efforts to send the jury back to deliberate 2 times, following notes that they were in an impasse, and in addition to finding that the jury had engaged in due and thorough deliberations, and providing the Tui Rodriguez instruction at the request of the defense, and to her satisfaction, during deliberations, the court amended the verdict slip to depict clearly the lesser included offenses and provided the jury a supplemental instruction on how to consider lesser included offenses. See, Bluford the Supreme Court has never required a trial court before declaring a mistrial because of a hung jury to consider any particular means of breaking an impasse, let alone to consider giving the jury new options for a verdict. And legally minded friends Karen Cole says, yay, doggy cam. That's right. We have unleashed the emotional support potato pig dog cam due to all of your awesomeness and support. And legally minded friends Karen Cole has put us down the path towards the new punishment shot at the $200 mark. We should, if we get there, we can talk about it. There's a new bottle that has replaced the really, really bad Korean single malt whiskey. there's another bottle I have to get rid of, and that's the only way I can do it. But we'll talk about that if and when it becomes necessary to do so. The defendant's claim that the judge should have inquired of the jury holds no merit, as nothing in our case law or in the statute required the judge to make either inquiry, whether there was a reasonable probability of any unanimous verdicts or if the jury would consent to further deliberations. True, the Tui Rodriguez thing and the comments surrounding that is that the court may ask them if they want to go back and continue deliberation. There's nothing that says the court must ask them if they want to go back and do more deliberations. But he's also saying that there's no requirement to ask whether there was a reasonable probability of a unanimous verdict. As a matter of course, and the circumstances before the judge did not necessitate either inquiry. The final note from the foreperson unequivocally stated that the jury were unable to come to a unanimous decision. It said on the charges. Again, we don't cut the quote short. I don't like Lally he seems to be doing this a lot. He's like, kind of going out on a few limbs here. He's taking a little liberty with the quotes. They said unable to come to a unanimous decision on the charges. Again, that can mean anything. Well, not really anything, but it can mean they didn't come to a unanimous decision regarding all the charges, or only the charges within count 2, or one or more of the charges, but unanimously acquitting on other ones. It's just not clear. In other words, the jury was deadlocked. The note did not suggest, for example, that the jury was merely having trouble making a decision or needed further instruction from the judge. Fuentes, court here, given the 4 days of deliberations, the jury's indication that they had carefully reviewed all the evidence and that their divergent opinions were premised upon deeply held moral convictions, the court was left with no reasonable alternative other than to declare a mistrial. Further consultation with counsel would not have produced any fruitful alternatives, nor was there a reasonable probability that the jury would have consented to deliberate further, particularly when the jury wrote, "To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs." Well, I agree with him on that point. I do agree that asking them to go back and deliberate further probably wouldn't have changed anything, because that's a pretty definitive statement that then to continue to deliberate would be futile. Moreover, whether counsel initiates contact with a discharged juror by first sending notice to the opposing party with the substance of the proposed communication, or if the juror initiates contact with counsel as alleged in the defendant's motion, counsel may communicate with jurors only about permissible subjects. True. Permissible subjects include counsel's performance during the trial, extraneous influence on the jury's deliberations, so outside influence, or a juror's bias towards a defendant. See Commonwealth McCowan. Neither extraneous influence nor a claim of bias is alleged by the defendant to have been an issue. Even in circumstances where juror testimony is needed to ascertain whether there was a racial or ethnic bias or extrajudicial influence, a judge may not inquire into the jury's substantive thought process, content of deliberations, or reasons for concluding guilt or acquittal. Okay, none of those are present here. None of those are present here. A judge may not inquire into the jury's subjective thought process. Okay. Asking what their verdict was, asking if they were unanimous on this charge, that charge, or the other charge, doesn't inquire into their subjective thought process. It just inquires about what the result was, the result of that process. What was it? Acquittal or deadlock? So that one's off the table. A judge may not inquire into the content of deliberations. And I don't think the verdict itself, the result of the deliberations, is considered to be the content of the deliberations. To me, the content of deliberations would be, what did you talk about? What did you say during deliberations? What arguments were made? So I don't think that is present in this case. And the judge may not inquire about reasons for concluding guilt or acquittal. Did you acquit is a vastly different question than what's the reason that you acquitted. So I don't think any of that particular case is relevant whatsoever. Is beyond distinguishable. It seems completely irrelevant to what's being argued here at hand. Rather, when the defendant's motion is entirely premised upon what is expressly prohibited inquiry is that the jury's deliberative process and the substance of the jury's deliberations. Okay, again, I don't agree with that, with what Lolly's saying. What the defendant's motion is entirely premised upon and what is expressly prohibited is, I don't believe the defendant's motion is not entirely premised on the jury's deliberative process and the substance of deliberations. The secrecy of jury deliberations has served as a bedrock of our judicial system. Inquiry into the jury's deliberative process would intrude improperly on the jury's function. Again, they're not intruding into the process. They're just asking, what is the result of that process? This is grasping to me. This is very, very, this is the Hail Mary, I think, here in the motion. Every good motion should have a Hail Mary clause at the end. That's what this is, I think. This is because this just doesn't make any sense in light of what the defense is asking for. The common law principle that is essential to the freedom and independence of jury deliberations and their discussions in the jury room should be kept secret and inviolable. Inviolable. My mind just blanked out there. It is essential to the freedom and independence of deliberations that their discussions in the jury room should be kept secret and inviolable was not, and arguably could not be overruled. There's these cases. It is improper for counsel to inquire with jurors through intermediaries the individual or collective thought processes of the jury. They didn't ask about the thought processes, the reasons for their decision. They didn't ask, as far as I know, the reasons of their decisions or the substance of their deliberations. And I don't think they asked about the substance of the deliberations either. So again, I don't think that particularly relevant to this case. Massachusetts continues to adhere to common law principles, barring inquiry into the contents of jury deliberations and any impeachment of jury verdicts based on information gained from such inappropriate inquiry. I don't think there was an inappropriate inquiry. I'm not buying this argument at all. I think the other arguments that were made above are much more compelling than this. This is just blather to me. It doesn't hold water at all. Similarly, it would be improper for the court to inquire through affidavits or an evidentiary hearing the substance of the jury's deliberations. I'm not going to continue to bang this drum. The judge doesn't have to ask about the substance of their deliberations. Just ask the results of the deliberations. If after communicating with the juror, an attorney wishes to secure an affidavit from the juror, any such affidavit must focus on extraneous influences and not the substance of the jury's deliberation or the individual or collective thought processes of the jurors or the jury as a whole. Trial judge acted within, in this case, Cassidy, the trial judge acted within discretion to declare mistrial where proposed inquiry of deliberating jurors could not be made without inquiring into the deliberative process of the jury. Again, don't ask about the process. The Supreme Judicial Court has instructed that whenever a judge asks individual jurors about the possibility of extraneous influences on jury deliberations, whether of jurors who are still sitting as jurors or jurors who have been discharged, the purpose of the individual voir dire is not to delve into the jury's deliberations. There should not be an inquiry into a juror's individual or the jury's collective thought process. Again, for the millionth time, I don't think it's asking about the thought process or the substance of deliberations. You're asking what the results of that thought process were, what the results of the deliberations were, not what the actual deliberations or thought processes were. Likewise, polling the jury on the various... Here's the answer to our polling question, I believe. Likewise, polling the jury on the various possible verdicts, deliberations during their deliberate... Let's try that again. Likewise, polling the jury on the various possible verdicts during their deliberations or after their discharge would constitute an unwarranted and unwise intrusion into the province of the jury, and the Supreme Judicial Court has cautioned strongly against the risk of coercion inherent in questioning jurors, particularly in individual colloquies. Okay, well, that didn't help at all, did it? Oh, look, here's a big quote from another case. Ray, this is the case of Ray. One cannot assume from the mere report of deadlock. Oh, sorry, this is from the Commonwealth v. Ross. One cannot assume from the mere report of deadlock that there is any final verdict lurking within that deadlock that may be extricated. One cannot assume, but one can ask. Don't assume, because, ask out of you and me, that old saying. You don't have to assume, you can ask. One cannot assume from the mere report of deadlock that there is a final verdict lurking within the deadlock that may be extricated. And again, maybe they weren't deadlocked on the murder trial. Anyway, in many instances, asking a deadlocked jury about potential partial verdicts would constitute attempting to extract from the jury something that does not exist. Asking a jury to report where they stand on the offense as charged invites a report that may be based on only preliminary tentative deliberations, if any, on the level of offense, or hasty resumption of deliberations concerning that level of offense in an effort to satisfy the judge's apparent desire for a decision. Such inquiries of the jury may succeed in extracting a partial verdict, but we could not have confidence that partial verdict was the product of a thoughtful and thorough deliberation process. The risks of juror coercion are too high, and the reliability of such partial verdict returned is too low to warrant such an approach to salvaging some partial result from a deadlocked jury. Well, okay, what if you bring all 12 of them in and they unanimously say without coercion, you just walk in and go, what was your verdict on count one? Guilty, not guilty, or undecided? I don't see any coercion there. I just don't see it. All right, let's embiggen the dogs. I'm tell you what, we're going to read along here. We got a couple more pages. Let's embiggen the actual word, so you're not just listening to me. You can read along. We'll put the dogs under here as usual. I am enlarging the document now. Y'all like the dogs, so I left the dogs up there. I did that. Believe it or not, that was not me boomering. That was me giving you some doggage while I was okay. So everybody hates the dogs. I get it. You hate the dogs. You don't want to see the dogs. All right. We'll just keep the dogs small forever. I was just figuring it would be story time, but we can do a read along here for the last few pages. No, I legitimately did that on purpose because I thought you liked to sing both. Anyway, see, now we can't see Yoda. Anywho, all right, we don't like that. So, all right, lesson learned. Commonwealth v. Roth. Similarly, even if a deadlock does pertain to some distinction between the various levels of an offense, a judge has no way of knowing whether the jury have in fact fully considered the offense as charged. Juror number one, as we sit here by ourselves, you and me and maybe the counsel in this room, Did you, in fact, fully consider count one as charged? Yes? No? Yes? Okay. What was your decision on that? Not guilty? Thank you. So the judge does have a way of knowing whether the jury, in fact, considered the offenses charged. A desire to extract information from a deadlocked jury does not solve the significant problems in attempting to do so. A court's inquiry into possible verdicts improperly intrudes on the jury's function. And the ostensible benefits to be gained by such a procedure are outweighed by its risks. For the foregoing reasons, the defendant's motion should be denied, as there was no verdict that acquits the defendant, no grounds for the court or counsel to inquire into the deliberative process of a discharged jury, the defendant consented to the mistrial, and the court properly declared a mistrial due to a deadlocked jury who was at an impasse due to their starkly divided perspectives on the evidence and their sincere adherence to individual principles and moral convictions. As such, retrial is not barred by double jeopardy or constitutional principles, and the Commonwealth may retry the defendant on the 3 indictments and any appropriate lesser included offenses. Respectfully submitted, Michael Morrissey, District Attorney, by Adam Lally and Laura McLaughlin. And here's the certificate of service. Righto. Well, there we have it. Ooh. As I said, I got to admit, I was persuaded by some of that. I would like to see another round of submissions. I would like to see a responding brief from the Commonwealth addressing those issues that were, I would like to see a responding brief from the defense addressing the arguments of the Commonwealth, and then another response from the Commonwealth to whatever the defense responds to. That's what I would like to see. I'd like to see them flesh out these arguments a little bit more. But I'm definitely going to look at a couple of those cases. We should talk about some of those cases, because there's some very interesting things. And again, I liked that both sides used the same case to make their point. That's always a good thing. That always provides for some good legal fighting, when both sides think that the same case is helpful to them and not the other guys. So many lawyers say poll the jury for the answers. Well, that's my baseline, is they should at least, I wouldn't say poll the jury for their answers. I would say voir dire them. Bring in the 12 jurors. Well, first, bring in the 4. This is what I would do, because, me, based on what I know now, I would bring in the 4 jurors, and I would say, tell me what you think is going on. You ask them the questions. Did you fully deliberate this? Do you think that you needed more deliberation to decide this? And what was your decision? And listen to them. And then if they are all on the same page that charge 1 and charge 3 are gone, count 1 and count 3 are gone, or even if they're only on count 1 should be gone, if they're all unanimous and say basically the same story, then bring in the other jurors to see if that's corroborated further, and then make your decision. I mean, at least they should talk to the 4 jurors and possibly to all 12 of the jurors. And I'm seeing here, as Chloe Alberts Revenge says, there are 5 jurors now. I saw that here. I heard the 5th that came forward was the foreman. Yes, on the foreman coming forward. That's the 5th one coming forward. We're seeing these, and I haven't seen that yet. Let's see. Karen Reed, 5th juror. Holy shit. Well, there we go. Nope. 5 days ago, that would be juror number 4, number 3. I'm not seeing any news about a 5th juror. Karen Reed. Use a different engine. News. I'm not seeing anything about a fifth juror. Jules says fifth juror hasn't been confirmed yet. Heather Mosher, fifth didn't officially come forward, so he doesn't count. Jeff, tell people to like, says Mary J. Hey, like this, people. There's 733 of you here and 707 likes. We've had probably about an 80% turnover, so we should be up to 1,000 likes. Everybody hit that like button. We'll talk more about that in a second, trust me. So, okay, we have a possible fifth juror coming forward. We can do that. I'll accept the possible fifth juror, and if it's the foreman, that would be interesting. Legal-minded friends Karen Cole says, I've been busy creating visual videos on this case, and one video did really well with over 100,000 views. Shoot, girl. Look at you raking in the ad bucks. Woo, woo. Good job. So replying to comments has been time consuming. I guess. Damn. Good for you. Also, yay, doggy cam. We got that already. So you get a twofer. Amy's positive pathways in Massachusetts. Rule 27 allows the judge to poll with a high case profile. She should have used her discretion accordingly. All three counts should have been asked. I agree they should have. Unfortunately, they weren't. So now what do we do? So I think we have to find a way to rectify that, which I said would be, for me, bring in people, bring in the 4, possibly 5 now, talk to them, and if it warrants it, bring in the rest. That's kind of where I'm standing at this point. Should Judge Bev have asked if they were hung on all counts? Oh, absolutely. Absolutely. That should have been separate inquiries. However you want to word it. Are you hung on all charges? Are you deadlocked on charge 1, or some way of asking that? No matter how she wanted to ask it, there should have been some inquiry into whether the deadlock was on all counts or only some of the counts, and if count 2 was the subject of the deadlock, was there any finding? You probably wouldn't ask about the lesser included. I would. Yeah, I would just, that's what I would do. There had to be some inquiry. There should have been some inquiry, and I was stunned that there wasn't. It was just like, all right, I'm not going to have them do it anymore. Get out. You're done. Mistrial. Bye. Go. Well, that grounds on appeal. I don't know that it'd be good grounds for appeal. But they're making the arguments now for the mistrial. So let's see how that plays out first. Yeah, no, I don't think it would be a grounds for appeal. As David Sorensen said, probably for this reason. It's pretty much the judge isn't required to poll them. So, yeah, I guess that's what I was going to say. It's in the judge's discretion, so I couldn't really see how it would be that way. Let's see how it goes. That's all we can do. That's really good. Next, I want to see another round of submissions to clarify the points here. Good stuff. Well, all right. That brings us up to date on the Karen Reed trial. If the fifth juror does come forward, we're going to have more to say about that. We'll look into that if there is an official fifth juror. And as soon as there's any movement on this motion to dismiss, we'll be covering that as well. But right now, we got to look a little bit forward to other things that have been piling up. And we mentioned it earlier on. Tomorrow, I've got to make a decision real quick whether it's going to be Laura Owens and Clayton Eckert or what the Hales. And whichever one doesn't get done, we'll do that probably next Tuesday. We're just backlogged on so much stuff. I'm leaning towards Laura Owens because there's so much, but I also want to do what the Hales because it's so much fun. I'm leaning towards Laura Owens, though. So we'll probably do Laura Owens tomorrow. And Thursday, we'll be doing the retro trial. And again, you don't have to have seen the first parts, the first 7 or 8 parts we did, because it's very easy to catch up. It's called the Florida v. Donald Hartung trial, where Donald Hartung, an older gentleman who was accused of murdering his 2 half-brothers and his mother in a ritualistic and or witchcraft slaying. Follow us for that on Thursday. Friday will be F It Friday. Whether it's Friday morning or Friday afternoon, I'll decide in the next 24 hours. So stand by for all of that. Mods, thank you. Thank you so much for being here. But I want to say first to you here in chat with 718 on now 711 of you concurrent viewers, make sure you hit that like button. We've got an excellent like ratio. Let's make it even better. Get that up there. And on Replay Crew, if you've watched the Replay Crew all the way to this part, please make sure you hit the like button as well. Subscribe. We're trying to push our way up to 77,600. Let's see where we are now. We are at, oh my God, we're at 77,598. I know there's 2 of you out there that haven't subscribed. There's 700 people here. I'm sure 2 of you haven't subscribed. Get down there and subscribe. If you haven't subscribed, jump down there. We could probably easily get up to the 77,700. But you just get down there and smash that like button. Let's make me feel all warm and fuzzy and get up to at least 600. We're at 77,598 right now. Jules says, I hope you cover the Black Swan murder trial. Email me, Jules. I know nothing of the Black Swan murder trial, but it sounds cool. It's a cool name. I'll look into it. All right. Again, 2 of you get down there and hit that like button, please. I mean, subscribe button. How about more than 2 of you? How about 200 of you? And if you have already subscribed, just double check to make sure you're still subscribed. That would make me feel super warm and extra fuzzy. And let's look at our like and subscribe poll. How did we end up with? We got 1,287 votes and only 776 likes. Like 500 of you are cheaters. We've had 500 cheaters in this chat. People, shame on you. Like, subscribe, do both of those, and then take the like and subscribe poll. Come on. How do we have almost 1,300 votes and only 782 likes? You guys make me laugh. Anyway, murder charges should be dropped. 2% of you say, nope, she should already be in jail. 3% of you say, nope, she should be tried on every single one of the counts. 14% of you say, yes, they should be dropped, but she should be tried. The murder charges should be dropped, but she should be tried on the other 2 charges. And 81% of you say, yes, the murder charge should be dropped. And in fact, all charges should be dropped. All right. Judge Bev rules right up there with Judge Grudge. And unfortunately, a lot of other judges, not just those 2. Ugh. Judge Bev isn't going to do anything until July 22nd. Yeah, we got to get to the status hearing. We'll see how that goes. I hope that if that will, oh God, what day is the 22nd? Is that Monday? Shit, that's Monday. I said we do a Maritime Monday. We might have to we'll find something. We'll do something. If they stream that, we'll do something. Right. Okay, peeps, that's it. We're going to wrap this up. We've got everything we need to take care of, except for King Ginger says, did you hear they found a cave on the moon? Nope. I'm going to go look at that right now. So in the meantime, everybody, mods, thank you so much for being here. Thank you so much for doing all your super moddy awesome stuff. And thank you, chat, for the support, the gifted memberships, the monthly membership chats, the super chats, all that other. Thank you so much for your generosity and your support of the show. And on behalf of Yoda, who you can probably see 1 foot. Yes, you can see the nether regions of Yoda. On behalf of Yoda, whose nether regions are on display, and Strawberry, who has gone over to the other side of the room. Thank you so very much for everything you guys do, for just being here in chat, for keeping everybody entertained, for doing all of that stuff. I will see you tomorrow, most likely for Laura Owens and Clayton Eckert updates. Don't miss that. Thank you, peeps. We will talk to you soon. Bye.
Sing, they're all insane. The fireman's blind, the police are lame. A black padded jacket and a framed up dame, cracking out the tail light. Cops are looking for fame. Clap hands, clap hands, clap hands. Said hide, don't you open the door. Son of a bitch is never coming back here no more. Bud Light in the bar and a Jeep on the street. We can always find a scapegoat here to take all the heat. Clap hands, scream, scream, 100 bad dreams. Everybody's butt dialing in their bed and jeans. A missing shoe and a cop's misplaced hat, and nobody's sure where Mr. Nevercracker at. Said hide, don't you open the door. Son of a bitch is never coming back here no more. Bud Light in the bar and a Jeep on the street. We can always find a scapegoat here to take all the heat. Clap hands, clap hands, clap hands. Scream, scream, 100 bad dreams. Everybody's butt dialing in their bed and jeans. A missing shoe and a cop's misplaced hat, and nobody's sure where Mr.